Báwo ni ṣe wà òkè akúdédé àsìkò yìí? Fún gbogbo ẹ̀yin tẹ̀sí ní interest lórí ọ̀rọ̀ Mohbad tó ń lọ lọ́wọ́, pàápàá láàrin Baba Mohbad àti Nairamally, SamLarry pẹ̀lú primeboy. Ṣé mọ̀ pé nígbà kan ni kóòtù sọ pé àwọn fi primeboy, SamLarry, Nairamally wọ́n fi wọ́n sílẹ̀ torí pé wọn ò rí ẹ̀sùn kankan tó ń rí kà sí wọn lẹ́sẹ̀. So ṣé mọ̀ pé Baba Mohbad kó padà kó lọ pè wọ́n lẹ́jọ́. So àná ni wọ́n ṣe tí wọ́n lọ sí court. Gbogbo Sunday sun court òun ni ìkan lára àwọn supporters Wùmí lórí TV platform ni wọ́n bá wa explain ìyẹn Mr. Pythagoras. So àwọn ni wọ́n sọ gbogbo nǹkan tó ń lọ ní court bí everything bó ṣe ń lọ. So máa bá yín gé sí ọ̀nà méjì, part 1 nílé ìjọba part 1 tán ẹ má gbàgbé láti wo part 2 kẹ́ mọ̀ gbogbo nǹkan tó ń lọ tó sì ń lọ láàrin Baba Mohbad, Nairamally, SamLarry pẹ̀lú primeboy àti àwọn court. So because wọ́n lọ court lánàá, so ẹ farabalẹ̀ kẹ́ gbọ́. Ẹ má dẹ̀ gbàgbé bẹ́ẹ̀ ṣe ń gbọ́, ìwọ tó bá subscribe kó subscribe, comment, má dẹ̀ gbàgbé láti like kó dẹ̀ invite àwọn èèyàn míì tí wọ́n bá ní interest. Ẹ ṣé gan.
Yeah, so basically, it's challenging you remember the last time DPP released it, or get the advice. I think sometime in February, they got an advice on the case file to along regarding the death of Mohbad. So, according to them, they took it to the High Court judge that based on this, what do you think? We don't think there's anything we can do here. We cannot really prosecute. We cannot do anything. Although we arrested these people on suspicion of this thing, we were investigating to see the link of their link to this crime. But as it stands right now, there's nothing we can do. What do you think, sir or ma? And they just said, based on that, we have to discharge these people. You don't have any evidence. Okay, because these people, part of the, what do you call it? Part of their right is right to fair and speedy hearing. Because they keep saying it, justice delayed is justice denied. Not just justice delayed for the victim. Yes, even justice delayed for the suspect. Because as a suspect, if you keep being a suspect for so long without any investigation concluding to pin you to the case, it's more like they're depriving you some certain degree of your rights. So it could lead to justice delayed for you too. So why the victims of any crime, why they need justice, even the suspect, everybody involved, whether in commission, whether investigating, they also need justice on their own part, depending on their role in the situation. So the court said, you know what, you cannot keep seeing these people as suspects forever. Since there's nothing you have right now that you can charge them with, let them go. If tomorrow something comes up, good and fine for you. But as it stands now, you do not have anything to charge these guys for. They have to go. That is part of fairness in law. In the justice system, it is part of fairness. So based on that, they got the advice, and based on that advice, SamLarry, Nairamally, primeboy, whether Obele or Obebe or whoever, they were discharged by the magistrate courts. Baba Mohbad Igbomu only know that why would they discharge them? Because there's still a pending issue going on in the coroner's court. The coroner is investigating how Mohbad died, when he died, and circumstances leading to his death. That because that is going on, the DPP and the court cannot just release the suspects or discharge them, as it were. So, yes, we can read the updates. Let me grab my second phone. I can read the update, but I want to give people the background to the story so that, because by the time we start reading, I know there'll be a lot of semantics there that will throw some people off. So, by the time I lay some foundation to it, it will be easy for everybody and anybody to follow the story. So, based on that, Baba took case to court. They say no, it will be miscarriage of justice if you're preempting the coroner's inquest by releasing people that they are not guilty or they are not involved in the death of this boy. That will be like you're preempting. It's like you're guiding the coroner inquest. Like, I only you can you look somewhere else for your evidence or for your guilty fellows, if at all they are guilty people here. So I think the court today, they now had the opportunity. It took the case to court, and you know our court system. They will file the application. They will depose to some oaths and things like that. And whoever they are bringing the case against, in this case, you call them respondents because it's a criminal case and it's a private person against the state. So they are the respondent in this case here now. They will also file their own counter affidavit, counter application if they have, or any motion. They will do all that. They will continue doing all that. There will be some back and forth in the background. But today was for listening to arguments. They had to come. They went to the court today, or maybe or yesterday in some people's place now. Each side arguing their case. That this is why I'm saying these people have no legal standing. These people, whatever they have done, is going to lead to injustice. And the state, they responded as the DPP. I think the police was the police is also part of the respondent too. And I don't know who else. They will also make their own argument that, you know what, this man doesn't know what he's saying. This is how the case looks like, and all that. So that's what happened in court today. And I think Channels TV was there or they had their reporter there to cover the event, and they wrote a story about it. And ẹ lọ jókòó, ẹ wá nǹkan jókòó lé kí n kà á fún yín. So where is this? So the Lagos High Court sitting in Ikeja fixed July 2, 2025 for its judgment in the application by the father of the late singer Mohbad, Mr. Joseph Aloba, seeking permission to quash the DPP's legal advice and court proceedings, which freed Nairamally and SamLarry on allegations of being involved in Mohbad's death. That is the heading. So, Justice Taiwo Olatokun fixed the dates after taking arguments for and against the application from counsel representing the applicant, Mr. Joseph Aloba, Senior Advocate of Nigeria, Wahab Shitu, and Joke Ametre, who represented the respondents. The applicant, Mr. Joseph Aloba, is suing for and on behalf of the Aloba family, while the Attorney General of Lagos State and the Director of Public Prosecution listed as the respondents. So those are the respondents, the Attorney General of Lagos State and the Director of Public Prosecution, that's DPP. So Senior Advocate Wahab Shitu cited a lack of fair hearing as one of the grounds for the application. So you bring an application to court, that will be like the basis, the foundation for the lawsuit. You're applying for something that we want this, whatever judgment they've gotten, we want it quashed. We want it rendered null and void. And you have to give reason that why are you quashing this? Why do you think this is wrong? And part of their reason is that there'll be lack of fair hearing. That's part of their reason. So in his application, Mr. Aloba had said the DPP's legal advice freeing the duo of Nairamally and SamLarry preempted the proceedings of the coroner's inquest, which is here to conclude its inquiry and sitting into the cause of death of the late Mohbad. He noted that vital suspects mentioned and implicated in the coroner's proceeding have been freed by the DPP's legal advice. So I'm trying to put a little bit of explanation here and there. So what Aloba is saying here is that advice they got from the magistrate court in Yaba, freeing Nairamally and SamLarry, that is preempting the coroner's inquest. More like saying, no, the coroner inquest is not going to find them guilty anyway. Why not just free them now? So and they are now saying people implicated, according to Joseph Aloba and his lawyer, that SamLarry and Nairamally, that according to them, they're saying they have been implicated in the proceeding of the coroner's inquest, that they are vital suspects, and that the DPP's legal advice has decided to free them. So, continuation. In their counter affidavit, that's the respondent now, filed June 24, a legal assistant in the office of the DPP, Uday Ibrahim, deposed that contrary to the admission of Mohbad's father, the suspects who were released by legal advice were not acquitted, but discharged. So while we are going on, if you have the time, you can quickly check the difference between being discharged and being acquitted in the court of law. Also, the difference between being discharged and acquitted as against the other two. Let's continue. The deponent, that's the lawyer from the, what's it called now? The lawyer from the DPP. That's who they mean by the deponent here. The deponent said he was informed of the facts of the case by one Mr. Akinde Oluwaseun, a chief state counsel in the Directorate of Public Prosecution, which facts he believed. Because this guy, the lawyer, the Uday Ibrahim, is one of the lawyers in the DPP. So he needs to, whatever he's deposing to, it's like swearing an oath there. So he's saying this is where he got this information from, and he believed that person. That person happened to be somebody who is senior to him in the office, like a guy to who in charge of his share. They now explain the fact of the case to him that this is what happened here. Don't mind these people. This is what actually happened. Basically, they gave him the case file. So, and he believed it. So in the document, Ibrahim, that's the lawyer in DPP, Ibrahim stated that the respondents, now, don't forget, is the Attorney General and the Director of DPP himself. So the respondent admits paragraph 8 of the affidavit in support of the motion, only to the extent that its officers participated in the hearing of the inquest into the death of the late Oladimeji Loba, and also to the extent that upon conclusion of investigation by the police investigators into the death of the deceased, the investigators forwarded a duplicate case file to the office of the second respondent, that's DPP, for the purpose of review and issuance of legal advice. So what this paragraph is saying is that there are some affidavits that what's it called? Joseph Aloba gave. When you bring in this your application, you want to start a lawsuit and things like that, you will make some affirmation. So you call it affidavit, like this is what I know about this. I know this has happened. I know this has happened. I know this has happened. Based on that, I'm asking for this. And you will swear that this what you're saying, to the best of your knowledge and recollection, that is the truth. If anything is found to impeach whatever you have said there, then you can be sued or you can be charged for perjury, for lying under oath. So what that paragraph is now saying, that in Joseph Aloba's affidavit, there are different paragraphs there. That in the paragraph 8, that they agree with some of the things that was said there, and they mentioned what they agreed there, because a whole lot of things was said in the paragraph 8. And the things they agree with there is that, yes, so we participated in the hearing into the inquest into the death of Mohbad. Yes, we participated as one of the authorities there. And when the police also concluded their investigation, the police forwarded a duplicate file to us. And the purpose of that is for us to review whatever the police did with that. Because in a way, they are like an oversight function. They are like people who review the work of the police officers. Okay, you've done this, you've done this. Are these things lawful? Can we take it to court and get anything out of it? So they send the duplicate file to DPP for legal advice and for review. And they agree that, yes, we know about this one's true. So the next paragraph. Contrary to the deposition in paragraph 4, and generally in the applicant's affidavits, the suspects who were released by the second respondent's legal advice were not acquitted, but only discharged. It's reaffirming that here, that these people, they were not acquitted though. Now only discharged, they discharged them. Oh. So the respondents deny the deposition in paragraph 7 of the applicant's affidavit. So basically, what they're doing as part of the argument in court is that putting hole in whatever Joseph Aloba said, now him bring case come, that this and this and this and this are what he believes in. So the job of the opposition, in this case, the Attorney General of Lagos State and the Director of Public Prosecution, their job then is to put holes in that story. Now, you said here in paragraph 1, no, this is how it should look like. That is their job. If they are able to successfully puncture their story, then there won't be any case. That is the point of all this back and forth. So the respondent now is now denying. It denies the deposition in paragraph 7 of the applicant's affidavit in support, as the presiding coroner is here to pronounce a verdict which implicates the release or suspect. So this 1 year is heavy, if only you understand what is there. So he's now putting it back, because the basis, one of the basis of the case of Joseph Aloba here, one of the, I'm not really looking at comment section, so if there's something I really need to attend to there, somebody might have to unmute and let me know. But let me just finish the reading, and I know I'm doing too much of explanation in the middle, but let me just land. So what that paragraph is saying is that Joseph Aloba's, one of the foundation of his case is that the coroner, some people have been implicated in the coroner's proceeding. If you were following my reading, it was maybe in the second or third paragraph that I read, that why would the legal advice release these people when they have been implicated in whatever was going on in the Corona inquest. Now, the DPP and the Attorney General, they're now putting it back to him that the Corona magistrate has not, whoever is presiding over, has not pronounced any verdict that these people we have released, or they are implicated. Now, why are you now implicating them by your own words? Why are we going to keep them suspect forever when up until this moment they have not been implicated? The coroner judge have not pronounced that this person, hold them title, say this person and then do this, that on what basis should we now continue to label them as suspects? That is essentially what that paragraph is saying. So while asking the court to dismiss Mr. Mohbad's application, not Mr. Mohbad, here is Mr. Aloba. Mohbad, the local application. So while asking the court to dismiss I'm going to replace the Mohbad with Aloba, Mr. Aloba's application in the interest of justice, the respondents traced the process of obtaining the DPP's legal advice, the role of the DPP, the kind of information, notably the criminal case file, which the DPP, neither the coroner nor the applicant had access to, concluded that there was no fact disclosed which linked Nairamally, SamLarry, primeboy, and Okpere Babatunde directly or remotely to the death of Mohbad, a situation which formed the basis of the DPP's advice, freeing them. Yes, I know this one is loaded, this paragraph. So what this paragraph is saying is that the lawyer is saying why the DPP got this legal advice, why they went to court for this legal advice. That is because of the case file, the criminal case file, that the police, the investigating officers forwarded to them. They are now pointing to it that the DPP, they have this case file. They are now saying the coroner inquest or the applicant, that Joseph Aloba and his lawyer, that they do not have access to this file. That why, how, or on earth, or based on what we they say, whatever they have done. Some people have investigated this issue. Authorities have investigated this issue. They have forwarded their case file to us. You don't have it. Even the coroner magistrate, it doesn't have the what's it called? The case file. And that it was a case file they based their legal advice on to freeing these people, discharging them. That is the basis. There is not like they have any other special interest, that they're only working with the facts available to them. Basically, that's what they are saying there. So he said that's still the lawyer arguing. Contrary to the deposition in paragraph 8, now they have moved to paragraph 8 of the applicant's affidavit. That's Joseph Aloba's affidavit. They said Oluwaseun Akinde Esquire, from his experience as co-counsel, knows as a fact that the police is bound to send the duplicate case file to the respondent in any case file in which a prima facie case of an offense triable by information is disclosed, such as the one under reference is disclosed. So he's now saying that on Joseph Aloba's affidavit, I don't know if I can get the affidavit somehow, but I don't think it's available online or anywhere. So basically, from I can infer from whatever has been said in this paragraph now that in Joseph Aloba's affidavit, a paragraph there, paragraph 8, is saying that why is the case file forwarded to the DPP and the Attorney General. So it's now putting it to them that it is a non-fact that the police is bound. Bound there means bound by law. They have the obligation to send the duplicate case file. Yes, maybe not the case file itself. The original case file will still be with the police, but they have to duplicate whatever, the document, everything they've done, duplicate it, send it to the DPP. It is the law, especially when they have prima facie case that on the surface, that's the big word, the prima facie is not just on the surface. If you feel, if the facts can speak for themselves. If you, for example, you go in and you see somebody with a knife stabbing another person, the case itself has its own merits. And the merit is that you were witness stabbing this man. If this man dies, we can really hold you for it. So there is a merit. The case itself has its own merits. You don't need to start any detailed investigation. So that's the meaning of the word prima facie there. That's so the police is bound. When things like this happen, they are bound by law to send the duplicate case file to the DPP. So it's still part of putting holes in Joseph Aloba's affidavit. Let's continue. So, further to the above, the respondent states that at no time did the presiding coroner looking into the death of the deceased issue any directives that mandated the respondent to inform it of the conclusion of the second respondent's review of the duplicate case file, which is the conclusion captured in the legal advice sought to be quashed by the applicant. So here is saying that we are doing this and we have done this, and at no point did the coroner inquest issued us any mandate or any directive that, you know what, I want to see uh, your file after you review it before you go and do anything on it. That if there is no law, if there is no authority asking them to do this, why should they go out of their way to do things they are not required to do by law? If the law is saying this is how you do this thing, they have a process, they have a procedure. Why should we go outside of that procedure? So what they are saying that if the coroner inquest had told them that, you know what, if you finish reviewing this thing, send that, we want to see that file. We want to use it for this case we are doing. Then they would be bound by law to send before they go to the court to ask for legal advice. That is what that paragraph is saying. So it's still like they are arguing their case that these people don't know what they are doing. These are things should look like. So the second respondent, which is the DPP, was not instructed to halt his mandatory statutory review of the case file, nor ordered by the first respondent, which is the Attorney General, or the presiding coroner, or the chief coroner for Lagos State, to inform the honorable presiding coroner whenever it was ready to issue the legal advice. Saying at no point, that's what I'm trying to explain that to now, that DPP did not get any instruction, any ceasefire, any directive from whether the Attorney General knew, or from the Chief Coroner of Lagos State knew, or from the judge presiding over the issue of the issue at the coroner inquest, that they didn't get any directive from them that they should stop what they have been mandated by law to do. Because yes, even if the law gives you a power to do something, the law still puts some power in some people's hand to tell you, yeah, stop, don't do that thing. They are now saying, if the law has asked us to do something, nobody's telling us not to do it. No other authority is telling us not to do it. Why should we now halt? Why should we stop doing what we should do? Why should we stop our mandatory, our statutory obligation, our statutory duty? So they are saying they're acting in the bounds of the law. That why should they stop? Now, even when they have that, why should they come to tell the coroner that, oh, we are ready for legal advice now? If nobody's telling them this is what you have to do, They have their procedure backed by their laws. Anything that will stop them from going that way would be another instruction coming from an higher authority. So the police, in addition, the respondent states that it was the police investigators who, for the purpose of remand proceeding, pending their conclusion of investigation, presented the suspects before His Honor, Mrs. A.O. Olatubosun, who subsequently remanded them while awaiting the legal advice of the Directorate of Public Prosecution, the DPP advice. Let me read one more paragraph before I explain that. The police investigators were not instructed by His Honor, Mrs. A.O. Olatubosun, or the first respondent, that's the Attorney General, nor were the investigators under any statutory duty as part of the investigation to inform the presiding coroner that it was forwarding or had forwarded the duplicate case file to the office of the respondent. So, the police investigators and the respondents working on a prima facie criminal inference of the death of the deceased were independent of the presiding coroner. Good. So what those three paragraphs or four that I just read, what they're saying is that the police investigator, when this issue started and they started their investigation, because they had to hold Nairamally, SamLarry, and the rest, they had to hold them for more than 24, 48 hours as required by law before presenting a suspect, charging them with an offense, and presenting them in the court to have their own fair hearing. They had to go to the judge, this judge, Olatubosun, who eventually gave the DPP legal advice that they approached this judge that yes, these people, it looks like we're going to be holding them for more than 24 hours because we are still investigating this case. They have